Hello, and welcome to Topic 9 lecture, where we are going to be covering the evolution of sexual assault law. Today, for the most part, sexual assault is taken very seriously by the criminal justice system. And we have feminists and allies to thank for those improvements. As you're going to see in both the textbook and in the lecture, that it was feminists who brought the concerns regarding sexual assault to the forefront of the American political system. The stigma of pressing charges, the fear that the criminal justice system will not take the complaint seriously, and also the uncertainty of conviction, all of that's been significantly reduced. It's still present, but it's better now than it has been in the past. Obviously, this has not always been the case. In the past, it's been much more difficult to get the criminal justice system to take sexual assault seriously. And so this lecture examines the evolution of sexual assault law in the United States. If you want to pause this video lecture for a moment, and go to Canvas where the other video lectures are, there's this video that you can watch. So if you want, go ahead and watch that video. I think that would be really good. It's only about less than a couple of minutes. And then come back and continue on with the rest of the lecture. So even though the video that you watched is sort of funny, it does illustrate the persistent assumptions that are made about sexual assault, both in the criminal justice system, but also in society at large. That you see that it's the victim who's as being seen as at fault, that something the victim wore, or something the victim drank, or something that the victim did that brought about this crime. And that the crime is treated more as sexual in nature than violent in nature. That sexual assault is really not a violent crime, that it has to do something more with sex and sexual attraction, which is not the case. There's an assumption that the victim is lying or not fully remembering what happened. And that there's this attitude that if there's no physical harm or evidence of intrusion, right, that no assault, no crime took place. And also that, as you know, that pursuing the case, that it can be more beneficial than detrimental, and you've really got to force the criminal justice system to do their jobs. I had you watch this video because even though some of those things are still present today, that it's these sorts of assumptions that really shaped sexual assault policies and sexual assault laws prior to the 1960s. Until the 1960s, common law was the dominant driver in sexual assault policy in the United States. And then from 1960 to the 1990s, we see a turn away from common law and a move towards states codifying sexual assault laws into their state level laws, and that we see that there is national reform. And so we're going to dig into both of these areas in more depth in one moment, and we're going to start with common law policy prior to the 1960s. As the previous slide indicated, that until the 1960s, common law is really the understanding of sexual assault. The common law is the driver in terms of how sexual assault is treated in terms of policy. So I want to make sure that we understand what common law is, okay? So common law is law that's based on the customs of a society and also the legal precedents, okay? And the legal precedents are oftentimes a reflection of the customs and traditions within a particular society. A common law is often not written. It's not written or officially documented within state statutes or federal code. That it's unwritten, and it's often just a reflection of how courts have ruled on a particular matter that comes before them. So in the case of sexual assault, if the court is trying to decide should they prosecute somebody who's engaged in sexual assault, under a common law sort of theory, they would look back at, they'd say, okay, well, has a court heard a case like this in the past? If so, how did they rule? And then they would use that ruling in order to decide the case that's before them, as well as cases in the future. Like all law, common law often reflects the prevailing beliefs, morals, and social norms that are in force at that point that the legal precedent is made. Under common law, sexual assault is narrowly defined. For the most part, when we're talking about sexual assault under the common law, we're really talking about rape. That was what was considered sexual assault. And rape was very specifically defined in common law. That is the penetration of the vagina by the penis with extreme force. If there was no evidence of extreme force, then there was no rape and there was unlikely to be any sort of prosecution. As because prosecutions of other type of sexual assault besides rape was very infrequent in the common law structure. Under common law, rape was a serious offense and it had a serious penalty. But the thing is that so-called real rape rarely happened. So keep in mind that real rape was penis vagina penetration with extreme force, okay? And the reason that real rape really rarely happened and therefore was rarely prosecuted is because that any rape that didn't involve some sort of extreme physical evidence of extreme physical force was considered to not be rape, and that was because like the mindset was that a virgin or a faithful wife would have resisted attempts at sexual penetration until death in order to protect their chastity and to protect their fidelity, right? And so they would basically, resist, to the point of death. And so therefore, if somebody was trying to rape them, there would be all this evidence of extreme force. And on the flip side of that, if there wasn't the evidence of extreme force, well, they didn't really resist hard enough, right? And so therefore, maybe they like really wanted to have sexual intercourse with somebody else. And so, the thinking about rape in those common law terms indicates too that the primary concern here isn't about the harm that is done to a woman, right? Or the person that is being raped. But really the harm is to sexual chastity or marital fidelity. And so in some ways that this is seen as a harm to fathers and a harm to husbands, right? You have this faithful wife, you have this chaste daughter, and they're trying to take her fidelity and her chastity from you, right? The rapist is, right? And so that because they've succeeded in taking away her fidelity and taking away her chastity, right? That it's not really the woman who's been harmed, but it's the father or the husband who has been harmed, and therefore the court must come down severely on that person who engaged in that so-called real rape. And that's why other types of sexual assault were rarely prosecuted, right? Because, forced kissing or forced touching, right? And any of the other kinds of sexual assault, right? Those aren't really calling into question somebody's chastity or their fidelity, right? And so men will be men, and so there wasn't a need for that high level of prosecution because there wasn't as much harm as there was with actual rape. So, what are the implications of common law and criminal justice for sexual assault victims? Well, there are really tough standards that prosecutors needed to prove beyond a reasonable doubt that the woman truly resisted. And if you couldn't prove that the woman truly resisted the rape, then the person would be found not guilty. And so there must be physical evidence of extreme force. If you don't have that, you're not going to be able to get a conviction. Also, you have to have more than the victim's testimony under common law. The victim testimony alone was not enough, that it needed to be corroborated by other forms of evidence. Also, that under common law, that you are allowed to present evidence of the victim's sexual history. That's because if you were not a virgin or if you were not a faithful wife, that then you were not chaste, and that means that you've given into temptation before, so why not again? And so, there were really tough standards of evidence, making it very difficult to get a prosecution. That when it came to the instructions that were given to juries who were deliberating the guilt of somebody charged with rape, the jury was told that they sure, you could hear the testimony of the victim, but you really couldn't take that into consideration when making your final determination, your final verdict on guilt. That the testimony of the victim was heavily discounted because the thinking was is that the victim had good reason to lie. And so because of these tough standards, because that the victim's testimony really was, discounted by the jury, the prosecutors were really hesitant to charge. Because prosecutors want wins. If they can't win a case, then they're not likely to prosecute the case. And also, if you're not going to win the case, that really the victim of sexual assault doesn't want to go through the embarrassment of the trial, particularly under these standards used in a common law courtroom. And so it was, obviously a very bad situation. Another thing I want to bring up in terms of the common law and rape is that husbands themselves could not be charged with rape. As we learned in our section on marriage, that the theory of marriage that was enforced at this point was coverture, right? And so that women lost their legal identity once they got married, and that women were sort of seen as the wards of their husband, and so therefore under this thinking of marriage, that wives are to be sexually available for their husbands, and as such they cannot be raped. These were known as marital rape exceptions, and that some marital rape exceptions were actually on the books until the 1970s. By 1993, though, that husbands can be charged with raping their wives, and that marital rape was illegal in all 50 states as of 1993. It is abundantly clear that the common law system of sexual assault needed to change. But just because change is needed doesn't mean that change is going to happen. And it was because of the work of feminists and allies of feminists that at the forefront of drawing attention to to sexual assault, the prevalence of sexual assault in the United States, and also how difficult it was to prosecute sexual assault in a court of law. They brought this they brought this issue to the forefront of American policymakers, and so feminists identified a problem, and then they worked to get it on the agenda of those who make public policy. You'll read more about that in the book. There was also feminists focused on not just changing policy, but having raising consciousness about rape and sexual assault. Sexual assault it can be. It's very traumatic for somebody to experience. It's also something that you might be embarrassed telling anybody about, right? And so that there was a lot of silence going on in terms of not wanting to report sexual assault, even to your closest friends and family members. And so feminists, basically started reducing the stigma that was associated with saying that you had been sexually assaulted. And that they were in the forefront of creating rape hotlines where people could call and talk anonymously to somebody in order to get their courage up, and also to share in consciousness raising groups where women would come together and talk about sexual assault, giving people courage, and then also giving the fuel and the fire necessary for actually changing public policy in the United States. So, what were the goals of the reform of the rape laws that started in the 1970s? Well, the main goal was to move away from the common law understanding of sexual assault. And the best way to do this was to provide some uniformity in sexual assault law state to state to state. So, uniformity in state law. That what you may or may not know is that when it comes to criminal law, most of the power is devolved to the states. In the 10th Amendment of the United States Constitution, it basically says that states are responsible for defining what is a crime within the jurisdiction of their states. And so as you know, that there can be differences in terms of what is considered a crime in one state than in other. There's differences in terms of punishment and also jury instructions, etc. As it relates to criminal law. And so the first step was to say, okay, let's create a model penal code for sexual assault. And that came through the American Law Institute. And then there was an encouragement that each state adopts this uniform penal code for sexual assault. The reason to do this is because obviously it provides victims equal protection. That if you have different sexual assault laws state by state, sort of governed by the common law, the legal precedents that's within your state, that victims are going to be treated really differently, just depending on what the state that you live in, and that is not fair. Also, the changes to this model penal code for sexual assault was thought to increase conviction rates and rates of prosecution, and we'll talk about why that is in a moment. And that it also is designed to protect the rights of victims, particularly the women who are victims of sexual assault. So let's look at the specifics about how these goals were achieved. So what were the tactics used to improve sexual assault law throughout the nation? Well, as mentioned on the last slide, there was a move to adopt uniform laws in all states. And what these laws should do is that the first step is to define sexual assault in graduated degrees with graduated penalties. So under common law, as I said, that sexual assault was primarily defined as forcible rape, right? And that other sorts of sexual intrusions without consent were really not considered sexual assault. These new laws would have gradated degrees of sexual assault. And so if you sort of look at and think about like the sexual assault law that's currently in place in Wisconsin, it's a really good example of that. The sexual assault law in Wisconsin goes from first degree sexual assault all the way down to fourth degree sexual assault. And first degree sexual assault is the most serious. It's like forcible rape. But then, fourth degree sexual assault it's still sexual assault, but it's a sexual touching without consent, right? This gives prosecutors options to charge somebody with sexual assault and be more confident that they're actually going to, get a conviction. Also, there's a graduated penalty, right? The lower the degree, the less penalty. The higher the degree, significant penalty. Furthermore, these new laws should include any physical sexual intrusion, not just penis vagina, right? And so it could be, kissing, fondling, other sorts of penetrations that don't include the vagina, right? So that sexual assault has a much broader definition under these laws. Other aspects beyond adopting the uniform laws was to adopt what were known as rape shield statutes. Rape shield statutes are basically saying that past sexual conduct is inadmissible, right? And so that you under common law, you could put somebody's sexual history in as a part of the trial. In the new laws, reform laws, you cannot do that. There's a move away from use of force to absence of consent. And so sexual assault is because you didn't consent to be touched in a sexual way. That there's no more corroboration needed in sexual assault than in any other violent assault case. And so sexual assault is treated by the same rules and standards as other violent assault cases. And the Hale jury instructions, that is that the victim's testimony, the jury was said to heavily discount the victim's testimony. These new laws prohibit Hale jury instructions. The reforms that were made in the 1970s really transformed the criminal prosecution and criminal justice for victims of sexual assault. And so the impact of those laws should just not be minimized. Not that we are minimizing them. But that since this gets raised as an issue in the 1970s, that feminists and others concerned about sexual assault keep the pressure on. And so while there's wide acknowledgement that these reforms are really good, that there's still work to be done. And so in your textbook, you'll be reading about the reforms that continue from the 1990s into the present. And I'll just do a quick overview of these. In the 1990s, that there is federal legislation that is passed that furthers the prevention and also the prosecution of sexual assault. In the 1994, there's a big criminal justice bill that's passed during the Clinton administration, and that the Violence Against Women's Act is a part of that overall criminal justice bill. This is a law. It's drafted by then Senator Joe Biden, and it's passed into law. And the goals here are to provide federal grants to train criminal justice agents, police officers, and others in sexual assault and handling sexual assault. It also increases the penalties for offenders who cross state lines, that court orders are given full faith and credit between states, making it easier to apprehend sexual offenders. That there's also in the 1990s a focus on campus sexual assault with the passage of the Clery Act and stronger enforcement of Title IX, both of which you'll be reading more about in your textbook. And from 2000 to the present, that we continue to see emphasis placed on sexual assault. With the Me Too movement and the acknowledgement that there is lots of sexual assault in many industries throughout the United States, that there's been pressure to extend statute of limitations, that just because somebody's found to be a sexual assaulter and that many years have passed, that there should still be opportunities for prosecution. There's also been changes to non-disclosure agreements, which makes it difficult to prosecute people for sexual assault in industries like the entertainment industry and in other corporate industries as well. And there's been emphasis on making sure that rape kits are that there's a huge backlog and catching up on that backlog of rape kits so that people don't have to wait an unjust period of time to get their case heard by the criminal justice system. All right, so that's just an overview. We'll read more in your textbook, and thanks for listening. I appreciate your time and attention.